Stop scrolling right now because what I'm about to tell you in the next 60 seconds could completely change your immigration future. And most people watching this have absolutely no idea it's happening tonight. Not next week, not next month tonight. New green card rules go into effect that are already sending shockwaves through immigration law offices across the entire United States. And here's what's terrifying. The people most affected are the ones who think they're safe, the ones who filed their paperwork, the ones who've been waiting patiently. If you have a pending green card application, if you're on a work visa, if you have a family member inside the U.S. immigration system right now, you need to watch every single second of this video because missing even one part of what I'm about to share could cost you years, possibly everything. Welcome back to U.S. Visa Updates, the channel that has been tracking every single shift in U.S. immigration policy before the mainstream media even wakes up. I'm glad you're here today because today is not a normal upload. This is an emergency briefing, and I want you to stay with me all the way to the end because in the final section, I'm going to reveal the one action step that immigration attorneys are telling their highest paying clients to take before midnight tonight. That information alone is worth more than most paid consultations. So, do not leave this video early. Let's start with what's actually changing because I know you've probably seen clickbait headlines before, and you're tired of being misled. This is not that. These are documented, confirmed policy shifts that are taking effect as of today, and the scope of who is affected is genuinely staggering. We are talking about an estimated 4 to 6 million people currently inside the U.S. immigration pipeline who are going to feel the direct impact of these changes. That number is not exaggerated. That number comes directly from backlog data maintained by U.S. Citizenship and Immigration Services, otherwise known as USCIS. Here's the core of what's shifting. For years, the way green card priority dates were managed followed a relatively predictable rhythm. Applicants from high-demand countries, India, China, Mexico, Philippines already faced brutal wait times, some stretching decades. But the rest of the world operated under a system that, while imperfect, was at least somewhat navigable. What's changing now restructures how certain preference categories are prioritized, how adjustment of status cases are sequenced, and this is the part that nobody is talking about, how cases that have been pending for extended periods get reevaluated under the new framework. And that last part is where millions of people are about to get blindsided. Now let me slow down here and explain something important because I want you to actually understand this, not just feel scared about it. There are several preference categories under the employment-based green card system, EB1, EB2, EB3, EB4, EB5, and there's the family-based system with its own categories. What's happening right now affects multiple categories simultaneously, which is extraordinarily rare. Normally, policy shifts tend to be surgical. They target one category, one country group, one processing type. When multiple categories shift at the same time, it creates what immigration attorneys call a cascading backlog effect. Imagine a traffic jam on a highway. Now imagine 3 on-ramps merging into one lane at the exact same moment. That's what this is. And if your case is anywhere near that merge point, things are about to slow down dramatically or accelerate depending entirely on which side of the new rules you fall on. Let me tell you about someone I'll call Ravi. He's a software engineer from India, been in the United States on an H-1B visa for 11 years. His employer filed his EB-2 petition back in 2019. He's watched his priority date move forward, then retrogress, then crawl forward again. He's renewed his H-1B 3 times. He has a US-born daughter who is now 7 years old. He's bought furniture. He's built a life. He thought he was 2 to 3 years away from finally getting his green card. What the new rules do to someone in Ravi's position is exactly what we're going to break down right now. And I promise you, whether you're from India, Nigeria, Brazil, or anywhere else, this story is going to feel uncomfortably familiar. The first major change deals with something called the final action date versus the date for filing. If you've spent any time on the USCIS visa bulletin, you know these two charts can differ significantly. Under the old framework, when USCIS determined that enough visas were available, applicants could file for adjustment of status, meaning they could file their I-48B5 using the more favorable date for filing chart rather than waiting for the stricter final action date to become current. This flexibility was a lifeline for hundreds of thousands of people. It allowed them to lock in their place in line, get work authorization, get travel documents, and essentially live with much greater stability while they waited. The new rules significantly restrict when and how USCIS will allow the use of the filing date chart. In practical terms, this means the window to file your I-48E early, that window is narrowing or in some categories closing entirely. Stay with me because it gets more nuanced and more important. The second major change involves how USCIS handles what they internally categorize as aged-out derivative beneficiaries. This is heartbreaking, and I need you to understand this. When a parent files for a green card, their children are often included as derivative beneficiaries. But there's a rule. If the child turns 21 before the green card is approved, they can age out of the petition and lose their status entirely. Congress passed the Child Status Protection Act years ago to provide some protection against this, but the new guidelines are reinterpreting how USCIS calculates the age freeze mechanism under CSPA. For families who have been waiting a long time and with backlogs stretching 5, 10, sometimes 20 plus years, that's a lot of families. Children who believe they were protected under CSPA may now find that protection doesn't apply in the way they thought. We're talking about young adults who grew up in the United States, went to school here, built their identity here, suddenly facing a completely uncertain immigration status because of a formula change in a government policy document. That is not an abstract statistic. That is someone's kid. Now, here's where I want to introduce you to something that most creators in this space completely overlook. There's a difference between policy changes that are announced and policy changes that are implemented. Announcements create headlines. Implementation creates consequences. And the gap between those two things, that gap is where most people get hurt. Because what happens is this. A policy shift gets announced. Immigration attorneys update their guidance and cautious applicants prepare. But the vast majority of people, the ones with pending cases who aren't actively monitoring, the ones relying on their employer's HR department to track this, the ones who filed years ago and assumed no news was good news, those people don't find out until something goes wrong, until they get an unexpected request for evidence, until their case gets put in a hold status, until their work authorization lapses because their I-485 was returned or denied on a technicality they never saw coming. That's the pattern. And on this channel, U.S. Visa Updates, our entire mission is to make sure you're never in that group. You are watching this right now that already puts you ahead of millions of people who aren't. Let me address the third change, which is the one immigration attorneys are most animated about behind closed doors. This involves the processing priority sequence for employment-based cases and how USCIS has restructured the internal workflow for high-volume petition types, specifically I-40s and their connection to pending I-485 cases. Without getting too deep into the bureaucratic weeds, what's happening is that USCIS is changing the sequence in which it allocates visa numbers at the end of the fiscal year. The U.S. immigration system runs on a fiscal year that ends September 30th. Unused employment-based visa numbers from certain categories get reallocated, and historically, some applicants have benefited from these last-minute reallocations to get their green cards approved ahead of schedule. The new processing rules change how and when those reallocations happen, and critically, who is in line to receive them. For some people, particularly those in EB1 and certain EB2 categories, this could actually mean faster processing. But for a much larger group of people in the EB2 and EB3 backlog who were banking on reallocation as their path to approval this fiscal year, that pathway has just become significantly less reliable. And here's the open loop I want you to hold in your mind right now, because I'll close it before this video ends. There is a specific action that can shield you from the worst consequences of these reallocation changes. It doesn't involve filing new petitions. It doesn't require a lawyer necessarily. It's a documentation step that most applicants skip because nobody tells them it matters. I'll get to it. Don't go anywhere. Let's talk about the family-based side because I don't want anyone to think this is purely an employment-based issue. Family preference categories F1, F2A, F2B, F3, F4 are also experiencing turbulence. The F2A category, which covers spouses and minor children of permanent residents, had been moving at an encouraging pace over the last 18 months. New allocation modeling under the revised rules is expected to significantly slow F2A movement, particularly for petitions from Mexico, which already faces some of the longest waits of any country in any category. For spouses who are living separated from their partners, for children who are growing up without a parent present, this isn't just paperwork. This is daily life in a state of suspended uncertainty. And these policy changes extend that uncertainty in a way that is genuinely cruel, even if unintentional. The F4 category, siblings of U.S. citizens, is facing what some analysts are calling a near-freeze scenario in certain countries. If you filed an F4 petition for a sibling, and you're from one of the heavily backlogged countries, the new projections are not encouraging. Priority dates in those categories are not expected to advance meaningfully for the foreseeable future under the new framework. Now, I want to circle back to Ravi, the software engineer I told you about earlier, because his story has an important second chapter. When Ravi found out about these changes, he didn't panic. He did something smart. He immediately contacted his immigration attorney and asked one specific question. Not am I going to be okay, because attorneys can't answer that. He asked, what is the current status of every document connected to my case? And is there anything we need to update or resubmit before the new rules take effect? That single question uncovered something critical. His attorney realized that a supporting document in his I-485 package was approaching an expiration threshold that under the new processing timelines would likely expire before adjudication. They were able to address it proactively. If Ravi had waited even another 2 or 3 weeks, that oversight could have resulted in a request for evidence, a processing delay of 6 to 12 months, and potential complications with his work authorization renewal. One question, one conversation, potentially years of difference. That is the action step I've been building toward. Right now, not tomorrow, not next week. You need to do an audit of your case. Pull out every document connected to your immigration file. Check expiration dates on medical exams, on police clearances, on civil documents, on translations. Check the validity period on your advanced parole if you have one. Check when your employment authorization document expires and when you need to file for renewal based on the new processing time estimates which have shifted under the updated framework. Check whether your priority date is on the final action date chart or the filing date chart, and understand which chart USCIS is currently using for your category. If you're using an attorney, call them, email them today. If you're self-petitioning or using a non-attorney representative, cross-reference the current visa bulletin with your priority date and confirm your understanding of where you stand under the new rules. The people who get hurt by policy changes are almost never the people who were completely unprepared. They're the people who were mostly prepared, the ones who did the hard work of filing, of waiting, of maintaining status, and then got blindsided by one small thing they didn't know to check. Don't be that person. You've already invested too much. I also want to address something that's been coming up a lot in the comments on this channel. The question of what to do if you're currently undocumented or out of status, and you have a family member who is a U.S. citizen or permanent resident who wants to petition for you. The changes to how USCIS processes unlawful presence waivers and how those cases interact with consular processing timelines are significant, and I'm going to do a dedicated in-depth video specifically on that topic this week. If that applies to you or someone you know, make sure you're subscribed to Immigration Desk USA and have that notification bell turned on, because that video is going to be essential viewing. I also want to acknowledge something that I think gets lost in all the policy analysis. The emotional weight of this immigration is not a bureaucratic hobby. It is people's lives. It is families. It is years of sacrifice and hope and planning. Every priority date movement, every policy memo, every processing time update represents real human beings in a state of profound uncertainty, trying to build futures in a country that hasn't made the process easy. If you are going through this, if you are waiting, if you are worried, if you are exhausted by the unpredictability of all of it, I see you. And I want this channel to be a place where you get real, honest, actionable information. Not hype, not fear for fear's sake, but genuine insight that actually helps you navigate what is genuinely one of the most complex systems in the world. Before I close out, let me give you the 3 things you need to do today. And I mean today. First, pull your priority date and check it against the most current visa bulletin. Know exactly where you stand on both charts. Second, audit every document in your immigration file for expiration dates and flag anything expiring within the next 12 months. Third, if you have an attorney, send them a brief email today, noting that you're aware of the current policy changes and asking them to confirm your case strategy remains optimal under the new framework. If you don't have an attorney and your case is complex, this week is a very good time to schedule a consultation. The cost of a 1-hour immigration consultation is nothing compared to the cost of a misstep in this environment. These 3 steps won't solve everything. They won't make the backlog disappear or the policy environment less volatile, but they will put you in the best possible position, informed, proactive, and protected to the degree that anyone in this system can be protected. If this video gave you even one piece of information you didn't have before you clicked play, do me a favor, hit that like button. It takes 1 second, and it tells YouTube that this content deserves to be seen by more people who need it. If you're not already subscribed to Immigration Desk USA, subscribe right now. We cover these changes faster and more accurately than anyone else in this space. And with everything moving as fast as it is right now, you cannot afford to miss an update. And drop a comment below. Tell me which part of this affects you most, whether it's employment-based, family-based, or something else entirely. I read every comment, and your questions genuinely shape the content I make next. There's a lot more coming.